Thank you, Mr. President. Indeed, we do have a separation of powers at the federal level between the three branches of government: executive, legislative, and judicial. The key here, though, is the judicial branch members. The judicial branch cannot initiate a challenge. The challenge must come from a person or a party, or like the state of Minnesota. There has to be a case or controversy. They don't just review congressional action without somebody bringing a lawsuit. And that's what I think we should be considering, members, is whether or not the state of Minnesota should be engaged in a lawsuit to challenge the constitutionality of the federal health care bill on the grounds that we've talked about, and perhaps there are others. But certainly the Commerce Clause, which is a limited function of our federal government, and if they act beyond the limitations of the commerce power, the United States Supreme Court has said anything beyond what they have in terms of their authority is vested and reserved to the state of Minnesota. And that's the power and the division in the government that I'm talking about. We have an extra responsibility in the state of Minnesota, not just to look after the citizens and pass laws that apply in the state of Minnesota, but to hold our federal government accountable when they encroach and overreach on their constitutional authority. We are equal partners when it comes to the division of government in a clause like the Commerce Clause. And for us now, we have a great responsibility to step up and say, the state of Minnesota has an interest here. We are concerned about it. Our congressional delegation should look at the state's interest here, and our Attorney General should look after perhaps protecting and defending us in a court of law.